Thank you all for joining us here. I know we'll have some additional people coming in over the next few minutes. As you all know, climate change is an issue that we all face every day and is increasingly a central topic of the world that we live in. One of the issues that most affects climate change is deforestation. And there is a relatively new European deforestation regulation that we're going to address today. To do that, we have Nikolay Mizulin, who is a partner at Mayer Brown in our Brussels office. Nikolay is co-lead of Mayer Brown's International Trade Practice Product Group. He advises clients on all aspects of international and EU trade law, with particular emphasis on trade remedies, WTO dispute settlement, customs and sanctions, and today, obviously, the European Deforestation Regulation. Before Nikolay kicks off, we'll pass the microphone to Christian Roschman. Christian is a partner in the Twill and Checker Mayer Brown office in Sao Paulo, and he has a particular focus on agribusiness clients in the Southern Cone, who are obviously very much affected by this deforestation regulation. Christian, take it away.
Yeah, thanks, Doug, and hello, everyone. Just a quick introduction. It's not just the Christian, but rather our Brazilian offices. We have a very significant agri-business practice. We have at least 10, 15 partners in the office focusing on agri-business transactions and are familiar with the issues in relation to Brazil. And we would, of course, know that our clients sell the products in Europe and want to sell them in Europe. And that's why we thought this was really a great opportunity to have you all on the call. And I've seen on the list of people who signed up on the seminar that we have quite a number of our clients that actually listen in. So thank you very much for that. And I'll hand over to Nikolay now to get going.
Thank you, Doug and Christian, and thank you everyone for joining our webinar tonight. Today, let me show the presentation. I will put it on screen right now. Let me know if you see it. I think it should be okay right now. So, EU Deforestation Regulation is a rather fascinating piece of EU supply chain regulations. It's quite demanding in terms of requirements that it imposes on businesses. It's very strict and risky for businesses due to very significant penalties that might be applied in case of non-compliance. But most importantly for us as compliance legal professional, it is interesting because it's unique in a sense of a reversed burden it imposes on businesses. Unlike some other compliance instruments, say sanctions or other instruments, the burden here is reversed. I mean, in a sense that all products which are subject to regulation and destined for Europe, they're assumed to be non-compliant unless you're in a position to provide to the regulator a comprehensive and verifiable evidence that your products in fact comply with the requirements of the regulation. So it's pretty unique instrument where you need to have evidence in advance of you exporting or importing product into the European Union or selling it within the European Union. So I will try within the next 25 minutes or so to walk you quickly through the main aspects of the regulation and discuss a bit the compliance requirements that it sets forward. So let me start with...
And Nikolay, after you finish, we'll be open for questions and answers.
Sure. I mean, you can also post the questions as I speak, and we will tackle them thereafter. So, as a the first thing, what is the deforestation regulation about? And the idea is to eradicate from the EU market, from the supply chains destined to the EU, non-compliant products. So products that have been subject to being produced on the land plot subject to deforestation, or in some cases to forest degradation. The idea is that European Union with its market doesn't want to contribute going forward to the global deforestation. And the secondary objective is also to reduce carbon emissions. There is a perception in Europe that the more forests out there, the less carbon will be emitted. But of course, the EUDR also, from the legal and compliance perspective, is also about very significant risks. And that's why we have a webinar today. And the risks are very important to remind right from the beginning of this webinar. And you should remember that in case the product is placed on the EU market and it's non-compliant with the requirements of the regulation, that it comes from the land plot which was deforested as of 2021, for example, there are very significant remedies that will be applied by the European Union regulators. And it starts from the confiscation and prohibition of placing the product on the market to very significant fines of up to 4% of the EU-wide turnover. So for a number of businesses, these are very significant amounts. And also very importantly, from the point of view of reputation, the regulation foresees that the decisions which will establish infringements of the regulation will be made public and will name and shame essentially the offenders, and will also discuss the substance of infringement as well as the liability incurred. So all in all, one of the reasons why we are today is also to remind you once again that the implications of non-compliance with the deforestation regulation will be very, very far-ranging and significant. But going back to the basics of the scope of the deforestation regulation and how to approach compliance with it. So the first step is just to understand whether your company, your business deals with the commodities which are subject to the deforestation regulation, because EU doesn't have an ambition at this stage to regulate each and every commodity, each and every product. There are 7 commodities which are being targeted based on their contribution, at least according to the science that European Union has to the global deforestation. They identify on that screen. And the regulation targets not only the commodities, but also the products which incorporate those commodities. So the very first step in terms of understanding your exposure to the deforestation regulation is to look into the Annex 1 to the regulation and see whether you are dealing, as far as the European market is concerned, with any of the commodities and products listed in this Annex 1. Annex 1 has lists of customs codes which allow for relatively straightforward identification of those products. And the key thing to emphasize here is that if your product is not on the list, is not part of the Annex 1, for the time being, there is nothing for you to do in terms of compliance with the deforestation regulation. Yeah, you can basically disconnect from that subject, and including from our webinar today. The only caveat to that is that the Commission will be updating the Annex 1. It will be expanding it. It will also be reducing it, including through the FAQs, and we engage already with the Commission on the scope discussion, and there are some, for businesses at least, some favorable developments in terms of narrowing down the list. So one thing, just a caveat, that even if you're not on the list right now, if your products are not on the list, do check it regularly to ensure that you're up to date in terms of compliance. The second issue to examine in order to understand your exposure is the supply chain. How do you what do you do with the products which are listed in Annex 1? So if you're exposed through the products you handle, you need to look into what you're doing with them, because the regulation imposes obligation only on so-called operators or traders. And to simplify the definition, operator is someone like an importer who first places the relevant product in the European market. Can also be an exporter, because, and that's important to hear for the multinational businesses, regulation is fully applicable within the European Union as well. So if you produce something which is within the scope within the EU and sell it within the EU, the regulation also applies and obligations are also relevant. So the first thing after identifying the scope to check is whether you qualify as an operator, meaning whether you import or export, or whether you manufacture the relevant product within the European Union. Then you're going to have exposure in terms of obligations under the regulation. Also, if you're a trader, if you just buy an importing product from a third party and resell without further processing within the European Union, you will also be subject to the obligations under the deforestation regulation. So that is an important second step. At the same time, and we got this question pretty much every other time that we start working on the diligence system for the deforestation regulation. If you only purchase within the European Union a relevant product imported by a third party and just sold to you for processing into a non-relevant product, like if someone would import cacao from you and you produce a biscuit from it, then you are not subject to the deforestation regulation. So simple consumption and processing into the non-covered product is not subject to the deforestation regulation. That's important to properly grasp the scope of the obligations. Now, if your products are within the scope, and if you're an operator or trader, what happens next? Then you have to recall the key obligation under the deforestation regulation. And essentially the way the regulation operates, it's all about sticks, and there are no carrots involved. So the key obligation is that there is a prohibition to place relevant products to the extent they are non-compliant. And non-compliance, and I will come to that, means that they are either sourced from a land which was subject to the deforestation, or in some cases to the forest degradation. So that's the key principle, the key obligation in the regulation. It's a prohibition to place non-compliant products. And if you do so, if you place them on the market and they're non-compliant, there are going to be consequences, which we just discussed on the second slide. In practical terms, how does this prohibition work? How is it enforced? It enforced through what I refer to a reverse burden obligation, meaning that before you place the relevant product in the European market, you need to conduct a due diligence and ensure that you know where the product is coming from, and you have evidence that this product comes from a deforestation-free land plot. And the way it's formalized is through so-called due diligence statements. It's a document that each operator or trader needs to lodge with the electronic system within the European Union, where it will provide certain details on the product which is subject to a transaction, and will also certify that it's essentially deforestation risk-free. So what are the products which are considered compliant? Just to zoom into the substance of it. So the products considered compliant if they're deforestation-free. Very importantly, cutoff date is already in the past, right? It's the 31st of December 2020. The same applies to the forest degradation. The second requirement for the compliance is that the relevant product has to be manufactured in accordance with the local laws in the country of origin, and that would cover a finite list of different laws, such as environmental and similar provisions. And procedurally, for the product to be compliant, which is the way the whole regulation works, it has to be covered by a due diligence statement. And the due diligence statement should confirm, of course, that due diligence was carried out and no risk of deforestation content was identified. Now,
one quick question, sorry.
Sure.
Just at least I was wondering, could you just return to the previous slide? You said a cutoff date 23rd December 2020. This means that there may not be any cutting. The deforestation must have happened after. Or what is the exact meaning of this cutoff date?
The meaning is very simple. So if on the 31st of December 2024 there was a forest on a land plot concerned, and subsequently you have sourced a product from that land plot, but it was deforested, in such situation the product would be non-compliant. If, however, on the 31st December 2024 the land plot was already subject to deforestation and to land degradation, then your product will be considered compliant. The idea is that we try to capture and avoid any ongoing deforestation, as well as deforestation which took place as the 31st of December 2020. And the way you, in practical terms, identify what happened in the past, what was the situation on the 31st of December 2020 or afterwards, is through the satellite imagery, which is essentially the threshold evidence which will require to demonstrate the compliance. So you would need, and we'll just come to that, to the real meat of the regulation. If you send something to Europe which is relevant to the scope, you need to ensure through sufficient, verifiable, and adequate satellite images, essentially, and through the geolocation of the ultimate land plot, that your product is not sourced from a land plot which was deforested after this cutoff date. So the regulation is back looking in order not to implement wrong incentives, because if you would put a date in 2024 in terms of cutoff date, that would really create wrong incentives for the market participants as far as the exports to the European Union is concerned. So that's why the cutoff date is back in the past, and in principle, the past cannot be changed. Very quickly on what does the due diligence statement looks like. In principle, it's a one-pager, relatively straightforward to fill in at first sight, but very complex in terms of the roadmap that will need to be implemented to take you to being able actually to fill it in. So the due diligence statement will have to have, of course, operator's name, address, and importer number if the company concerned is involved in export or importation. The due diligence statement will have to identify the product by customs code, describe it verbally, and also provide the quantity which is subject to the transaction concern. So the due diligence statement will have to be batch specific or shipment specific. You cannot just issue one due diligence statement covering all your shipments going forward for a specific product or a specific customer. And very importantly, where it really becomes complicated is that it has to identify by using latitude, etc., the exact geolocation of all plots of land where the relevant commodity were produced. And that is the key requirement of the whole regulation, and that is the key requirement, the key aspect of what will have to be reflected in the due diligence statement. And also it has to contain, of course, a signed statement at the bottom, which will certify that due diligence was performed on the relevant batch or the shipment, and that the language is used, no negligible risk was found. There's a definition on that. What it means technically is that you have to be almost 100% sure that there is no risk of a product coming from a deforested land plot. Now, to get to the due diligence statements, there is a long road for the businesses to go through. Why? Because the regulation is very specific in terms of due diligence system, which needs to be set up for the purpose of compliance with regulation and implemented on an actual basis, meaning that before you're in a position to issue a due diligence statement, you need to take a number of steps, which will not only consist in terms of devising an overall compliance system and checking things here and there, but you will essentially need to implement 3 pillars of due diligence system, which ultimately will result in you having, before you place the product on the European market, comprehensive and verifiable evidence that the product is deforestation free. So the 3 pillars are somewhat standard for any compliance professional. You would need to conduct information gathering. You would need to run a risk assessment on the information you have gathered. And if you're not satisfied with what you see in terms of the risk that you're potentially taking on, and the regulation says there should be no risk of deforestation, you're supposed to implement certain risk mitigation measures, such as requesting additional information from the provider or requesting third-party certification of its compliance. The most complicated piece of compliance that we see right now in practice is, of course, the first one. It's the information gathering element, which is extremely far-reaching and demanding. Why? Because you need to liaise with your supplier and their suppliers all the way further down to ensure, first of all, the traceability of the product that you're placing on the European market, meaning that you need to get actual data on a batch-specific basis on the ultimate geolocation of the inputs of the product itself sourced from the country of origin. And not only that, having received the data on geolocation at this stage, you would also need to find a way to run it through the database with the satellite images. Because only this way you're going to be able to get what the regulation calls in very complicated legal terms adequately conclusive and verifiable information that the products are deforestation free. Essentially, the idea is that you will get geolocation from your suppliers on where the product is coming from or its inputs are coming from, and you would run those geolocation against the database which has satellite images before and after, such that in real time for a specific supplier for a specific batch, you're ultimately going to have not only geolocation details, but also satellite image, which will back up your compliance, which will be the basis of the due diligence statement that you will later on issue. And the task is not as straightforward as it seems right now, because there is a debate about which images to use, which service providers. There are different images are out there showing different degree of resolution. This is especially complex for the forest degradation, which is an additional requirement applicable for products containing wood, for paper essentially, and similar products. There you would need actually a very high resolution images in order to see whether the product, where the forest was degraded or not, because degradation is something in between there, where the forest was not deforested, but has been already converted to a different use essentially. So this first element, which is a lot of companies are struggling right now, there is not a single service provider out there. There are companies providing geolocation services, so all kind of blockchain and applications for farmers in order to have through the supply chain data on geolocation. There are special service providers who have satellite imageries, who can take geolocation and run against the images they have and tell you where the product is really deforestation free entirely or in part. And whether there is a forest degradation is involved. But that is essentially the key, maybe due diligence complication right now, but at the same time, it's also a key requirement of the deforestation regulation that information has to be gathered in advance, has to be analyzed and be stored in a proper fashion in order to properly generate a due diligence statement.
Hey, Nikolay, before we move on with this next slide, there are a couple of questions that are relevant to what you just covered. So let me read those out, and you can give us your view. So the first one is, what is the definition of negligible risk? What is negligible in the context of the EU regulation?
There's a specific legal definition. I just don't have it in front of me, but essentially you need to be close to 100% sure that the product is not coming from a deforested area. Just to make it simple and to put aside the legal terms, what they mean here basically is that you get geolocation, right? You run it from the database with images, and if you have ultimately a land plot identified through the images, which is 100% clean from the risk perspective, that is the level at which the risk of non-compliance is basically negligible. It's really from the imagery perspective and from the point of view of evidence that you need to demonstrate the compliance.
Okay.
That's the level of granularity that the regulator ultimately requires.
Related question. Besides the due diligence statement, which you've described, is there any alternative? Is there a stamp or a certification or an agency that provides that ahead of time so that you can avoid the due diligence statement? Or is the due diligence statement absolutely necessary in all cases?
The due diligence statement is necessary in all cases, and there's no exception to that, apart from certain exceptions for fully recycled products, which are basically outside of the scope of the regulation. So the due diligence statement is basically the key instrument, and the understanding is also that unless you file it electronically before submitting a customs declaration for import or export, as it may be, the products will not be released simply. There's going to be a link between the number of due diligence statement in the system and the customs declaration, and there are likely to be problems with the release of the product in a free circulation unless in the customs declaration you can identify already the number of due diligence statement that you have posted in advance. So the way the system is set up, also infrastructure-wise, is to ensure that, unlike, for example, for carbon tax, where you can import things and have liability later, for deforestation, you have to have evidence in advance. You have to lodge the due diligence statement in advance. And otherwise, for importation, exportation, the product will simply not be released. So there is no exception really. And the requirement is pretty extensive. And again, it's focused, maybe for the purpose of today's seminar as well, on the companies essentially within Europe, because operators and traders will be intra-European businesses first and foremost. There will be situations also with importers based in other countries, but a lot of burden will be shifted, of course, to the exporters, including in Brazil, Latin America, and other major suppliers of the products which are concerned. So a lot of burden will be shifted as well, but that would be burden essentially in terms of tracking the geolocation primarily. At the same time, the way right now the obligations are framed, the very high threshold legally set, it appears to be that EU operators and traders will have to do and have the settled imagery service providers on their own, rather than relying on anything that exporters in third countries can provide them with.
Okay, thanks, Nikolay. One last question for now. One of the requirements you mentioned is in the due diligence statement is that the production of the products is compliant with local legislation. If you have a country that has relevant federal, state, and municipal legislation, are there restrictions on things that need to be looked at? Is it only federal legislation, or is it possible that there are also other levels of legislation that need to be checked?
Of course, I mean, the regulation right now doesn't provide a finite list by country of the national laws that need to be complied with. It essentially is part of the due diligence and onboarding the suppliers going forward before, and I will come to before the regulation kicks in for real in the end of 2024, to ensure for each company that they have a list of what is reasonably has to be complied with in the country origin, and that there are checks implemented. That would be essentially a supplier certification in most of the cases, rather than the complicated story about geolocation and satellite images that I've discussed. The legislation, however, on federal and local level, I will guess both. I mean, it depends really on, because the regulation has a list of so it's labor laws, it's environmental laws, it's customs laws. I mean, it depends on whether in the jurisdiction concerned those laws are applicable. The list will differ. But in principle, like from the environmental point of view, from the point of land use rights, it's out of question that both federal and local legislation will have to be complied with. And one additional maybe comment on that, one very interesting feature for everyone to realize also, however, is that even if in terms of deforestation, even if you comply with the local laws in the country of origin, say in Brazil, that's still not going to be a defense for the deforestation issue under the deforestation regulation, because the European Union has its own way, has its own cutoff date, and has its own view as to what the compliance should be. So the compliance with the local deforestation law, narrowly speaking, is not going to be defense, because Europe estimates that around 30% of what it considers to be non-compliant comes compliant under the local laws. We're going to have here an autonomous decision-making on deforestation and forest degradation, narrowly speaking, by Europe. But all the rest will be subject to the local laws compliance indeed. Okay, thank you. We'll let you go back to your slides. Right. In many cases, when we start discussing the compliance program with the clients, the question immediately pops up that yes, there is the regulation is demanding. There's a lot to do. The compliance road is long and complicated. But really, I mean, will the European Union authorities be checking that? And what is the risk in real life of any of these penalties being implemented? It's important. It's a legitimate question because the compliance programs which the regulation requires are complicated and in fact rather costly going forward. And the answer to this question, in fact, is embedded in the regulation itself. The deforestation regulation is also unique in terms of imposing a very specific controls and checks obligations on the European Union member states authorities, because the regulation will be administered at each European member states by the authorities, and we'll get to know the name of those by the end of this year. And what the regulation says is that depending on the risk which will be assigned to each country in the course of 2024, there will be a minimum percentage of compliance checks to be implemented. So for low-risk jurisdictions, and risk designation may be country-specific, but also may target specific areas within a country as well. That's just important to bear in mind. But for low risk countries, the requirement will be to check at least 1% of each relevant product coming into Europe, and 1% of operators dealing with them. For medium risk countries, the percentages go to 3%, and for high risk jurisdictions, it goes to 9%, which essentially means that for high risk jurisdictions, and quite a few Latin American countries, Southeast Asian countries, African countries will likely end up in this category, at least for some of the areas within those countries. You should expect that basically every 10th container will be stopped. And for each of those containers, the regulator will require positive evidence of compliance. And at the same time, each 10th operator will also be checked. So to the extent that your business is sizable enough and deals on a permanent basis with the commodities and products which are being targeted, the risk of being subjected to the checks and being subjected to certain penalties in case of non-compliance is very high. And the regulation, again, is quite unique in terms of really setting very mandatory percentages on checks and controls. And you would expect that they will be implemented, not least because in the end of the day, you should also appreciate with everything Europe is doing in terms of compliance, that is compliance on the one hand, like carbon tax and deforestation, but on the other hand, it gives a lot of revenue to the local budgets. So that will be another hidden incentives for the checks and controls to be implemented at the level on top which the regulation requires. Some of the key dates to remind everyone before we move to the compliance dates. So because it's a very important aspect. So the regulation was published on 9th of June 2023. It entered into force on 29th of June 2023. As I mentioned, we will know the names of the member states' authorities by the end of this year, and we will also get to know the risk designation of countries by the end of 2024. In terms of compliance, what it means is we discussed the cutoff date. Very important date is 29th of June 2023. The regulation already applies, which means that everything which is being produced right now, it was produced as of the 29th of 2023. To the extent it will be placed on the European market as of 30 December 2024, will already have to be compliant, and evidence have to be compiled to ensure that the due diligence statement will be generated properly for that product. That's just very important to understand and realize that we're already within the validity of the regulation. And to the extent that the average turnover of your products is more than 12 months, we are almost there with the fact that your ongoing production and exports have to be supported by the relevant details on the geolocation and by the verifiable and comprehensive evidence on the deforestation free land plots. So that is quite important. So essentially, when it comes 29th of December of 2024, and you have in stock some of the production, which of course predates that date, even though the key obligations will start applying as of 30th December 2024, for everything you'll be placing and after that date, you already need to have evidence of compliance. So that is a very tricky part to remember, because there is not much time, in fact, to develop the due diligence system and start implementing it, because in principle, it should already cover the ongoing production. And 30th of December 2024 is the key date that we are working against with our clients as far as setting up the compliance. It seems to be far away, but because pretty much not a single major business for the time being is compliant, and a lot of requirements have to be satisfied and implemented, and the local ERP and IT system sets up, it clearly is a feeling right now that the time you have in 2024 to ensure the compliance is going to be rather short. Essentially, what we are doing right now is ensuring that the due diligence system is set up before the 2023, so that we can implement it on an ongoing basis in the course of next year. Something also on the compliance side, very important for those who want to look deeper into the subject, and that is the Commission's guidance on implementation. We don't expect the Commission to publish any book or guidance on how to comply. The Commission generally proceeds on understanding that everything is already explained in the regulation, and also through the frequently asked questions, which were published on the 29th of June 2023 on the date of entry into force of the regulation. Those FAQs are non-binding, but they do shed light on how regulators are likely to approach the issues. And you can see some of the clarifications that the Commission published. They are in spirit of the regulation. They are pretty strict and narrow in terms of interpreting possible exemption from the scope of compliance. So, for example, the big question for bulk products, especially for liquid products like fatty acid, for example, or fatty alcohol going into the cosmetics, which typically involves hundreds of land plots from where the palm fruit is sourced. How do you really go about demonstrating that they're compliant? And the answer is that you basically need to get geolocation for all land plots which participated in generating first the palm fruit and then generating the liquid product which was extracted from there. And all those land plots under the Commission's current theory, and that's the approach of the regulation, will have to go into the due diligence statement. So you just appreciate that a truck, say of liquid fatty alcohol going into the cosmetics, into shampoo going forward, as soon as it's sold within the European Union, will have to be accompanied by the due diligence statement listing probably hundreds of land plots going all the way to the palm fruit where it's coming from. And that's what the FAQs of the Commissions are trying to explain. They also explain that the mass balance method is prohibited. That makes sense to the extent that the legal requirement is to eradicate any risk of non-compliance, essentially. For cattle products, which is also very relevant for Latin American countries, the requirements are also quite overwhelming in terms of providing geolocations, essentially for any land plots where the cattle was raised and accordingly fed. We expect more FAQs to come out soon. We already know some of them because we've been in touch with the Commission and asked the relevant questions, which will go into the FAQs. Some of them are helpful. We reduced the scope, for example, for some of the packaging materials, for some of the marketing materials, for some of the things that companies routinely place on the market, but for which they're going to be difficult to comply. There is an understanding from the Commission to be reasonable, but at the same time, they do move and reply to those FAQs clearly in spirit of the regulation, which again sets very, very high standards for the compliance. So several takeaways from the presentation, and I will stop in 2 minutes. So the 30th of December 2024 is the compliance date. As of this date, for any product placed on the European markets or made available, due diligence statement will be due. And of course, that means that before that, due diligence system has to be set up and implemented on an ongoing basis. Bear in mind, however, that if you're going to have production in stock in Europe for import into Europe or for export from Europe on the 29th of December, you should also have already evidence of compliance for those products as well. Now, on the due diligence side, just to recap, the information gathering for all relevant products, whether from low, medium, or high risk jurisdiction, has to have a geolocation data going all the way back to the land plot. And for especially medium and high risk jurisdictions, the information gathering should also have evidence, essentially through satellite images, because this is the way the regulation operates, that the relevant products are really deforestation free or free from forest degradation. And for the high risk jurisdictions, right now, everyone is assumed to be medium risk, but based on the NGOs and the websites out there, we can reasonably suspect which high risk jurisdictions will be. For those already, while setting up the due diligence system right now, we are recommending the clients to implement risk mitigation measures, which to simplify simply means that if they want to sell to us into Europe or to the businesses here, they would need to go and implement third-party certifications, such as the one existing already for a long time for the palm oil under the RSPO certification system. So that is a nutshell, a walkthrough for today's webinar through the deforestation regulation. Again, I think the key thing to summarize, to remember, is that the burden as of 30th of December 2024 will be on you, will be on businesses. It's reversed. the regulator will not have to do much. They will stop a container and they will ask you to bring the file which positively and credibly demonstrate the compliance with the regulations through the credible geolocation data and through credible and verifiable satellite imagery. Remember in that context that what is going right now is that regulators are going through this process themselves. They're also looking for the suppliers of the satellite images services. They're going to be installing those servers at their locations, and they're going to be doing pretty much that they expect the compliance to do. They're going to be taking geolocations from the due diligence statements and running from their database from the images they have in order to see where the land plot concerned is really free of deforestation or forest degradation risk or not. So that is what is coming. We have until 30th of December 2024 to prepare, but the time is relatively short given a major compliant task ahead of us.
Thank you, Nikolay. We have a set of questions that have come in. First of these is if deforestation happened after the cutoff date, but the area is undergoing regeneration and recovery, and there's no planting, for example, soy being planted in the previously deforested area, will the farm be compliant? I think this question goes to the example of a large farm, let's say 10,000 hectares, but deforestation has only affected 1,000 hectares. Will that, if the relevant product, let's say soy, for example, is being produced in some of the 9,000 hectares that were not affected after the cutoff date, is that okay? Or does having any material component of deforested land on a, in a particular finca or farm create a problem?
Yeah, the way the due diligence is set up is that when you implement it on an ongoing basis and you get geolocation and you check it against the satellite images, and you see that part of the plot has been deforested under the definition that the regulation applies, that creates precisely the risk of non-compliance which needs to be eliminated. So that is a good illustration of a situation where the ultimate product will be non-compliant because there is a material risk of non-compliance. So the idea is that you need to keep, as a compliance officer, you need to keep that product of the European Union market. And I need to look into the regeneration separately, but I don't think that would qualify it under the definitions that the regulation use as being deforestation-free product.
Okay, thank you. Another question: does the absence of proof of origin of the product alone subject the operator to penalties? So if there's no proof of origin, no definitive proof of origin, does that create penalties, or is there a need to prove that the product is not deforestation-free in addition to that?
So the regulation uses this. I don't know. It's hard to see where they took this legal standard from because it's not coming from other compliance instruments. You're supposed to back up due diligence statement with conclusive and verifiable evidence, meaning that the way the regulator approaches is that that you have to provide them with a file which will have data on geolocation and will essentially have images to back up your due diligence statement saying that the product is deforestation free, which in turn means that if you don't know the origin, you cannot supply to Europe, which in turn means that in many cases, European operators and traders dealing with those products will, based on the requirements of the regulation, will have to disconnect as part of risk assessment, risk mitigation modules of the due diligence suppliers which cannot trace the products, which don't have traceability of the product to the land plot. So the only means to demonstrate the compliance is through geolocation and essentially for the satellite images. They don't foresee anything else at this stage, and I don't think it's going to be changed because this is how the whole setup now is being rolled out.
Thanks, Nikolay. Next question: who will have access to the due diligence data? So, for example, will competitors have access to the due diligence data, or will it remain solely in the hands of the EU?
The due diligence data, due diligence statements will have to be filed through the electronic system, and it's only the company submitting it, and the regulator will have access to it. For traders, however, the due diligence, so for the traders, so the companies that will buy from an importer and resell within Europe, the requirements are somewhat less burdensome. They can rely on the number of due diligence statement from the operator. So in that case, at least the number of due diligence statement will have to be passed, and it will mean basically that they can rely to a certain extent on the due diligence statement of the operator. But apart from that, there would be no public access to the further details of the information which is provided in the due diligence statement for a specific batch or shipment being sold. Several things, however, on the publicity. One is that there is a requirement in the regulation to publish on the website, essentially, of the company, the name of deforestation officer, the due diligence system, the procedure for the NGOs to file complaints with your company about non-compliance. So there's a big piece of a disclosure requirement for the setup about how your business complies with the deforestation regulation, but it's not going to be specific to shipments or batches. At the same time, the only thing where disclosure will come in is going to be on the negative side. So if there is an infringement found, the decision will be published, not entirely, but some of the details of the judgment or decision will be made public, which is the name, the substance of the infringement, and the penalty. Those things will be in the public domain, and essentially the idea is just to name and shame the offenders. But again, just to wrap up, the content of the specific due diligence statement will not be made either public or accessible to the competitors.
Okay, thank you. You mentioned, Nikolay, that each shipment has to be accompanied with its own specific due diligence statement, which for large companies with multiple shipments a month, will be a significant burden. Is that right? Each individual shipment?
Yeah, that's right. So the idea maybe is to replicate the customs declaration. So you bring you bring a vessel, you bring a truck, and typically per vessel or per truck or per container, you would have a customs declaration. So the idea is that for the same amount of shipment, if I can put it this way, you would have also a due diligence statement, because otherwise the customs declaration won't be in the system. We will not be able to match to the due diligence system, meaning that customs won't be able to release it. So the logic is to have the two things converge, which for us on a practical level means that for the importers of products in Europe, they will need to ensure that together with any documentation they otherwise require from the supplier, origin certificates, bills of lading, contract, etc., all this document package, they would also be requiring for exact same quantity in order to populate the customs declaration. They would also need all the data to populate due diligence statement, at least as far as the geolocation is concerned. So on that basis, it will have to be rather granular and batch or shipment specific. Yeah.
Okay. Related question: will these requirements to collect and hold data apply to individuals also? And if so, for example, individual farmers, how does that align with data privacy legislation?
It's a good question. So from the farmer, I mean, the deforestation regulation legally, I mean, it really doesn't, I can't say it doesn't care about third country operators. It does, and there is a requirement to communicate the requirements to the country of origin, of course. But all the requirements, and the one who's going to be liable, and the only liable in the eyes of the EU regulator, will be operator or trader within the European Union. So everything, he will be fined or subject to all other remedies. Now, of course, the European operators will not be able to prepare due diligence statements without an input from the suppliers. But for the suppliers as such, it will essentially depend on what the European consumers of yours will impose on you. It's not going to be a mandatory system coming outside of the European legislation. I mean, the legislation says that you have to keep for 5 years the records, but that's the obligation on the European operators or traders who who put together and lodge the due diligence statements. As far as the suppliers and farmers in third countries are concerned, it will really depend on due diligence policies that the European companies will develop and sort of impose on their suppliers. But going back to the farmer, from the farmer, really the only thing which is required is that he or she provides a geolocation. So provides essentially together with I don't know, whatever paperwork, but at least there should always be a piece of paper, including coming with a raw wood. There should be always essentially a piece of paper which identifies where the product's coming from. And typically, like for a lot of wood, from what I've seen, geolocation is already being collected and identified. So the farmer as such, I don't think there will be a legal requirement from EU to have these records. European customers will impose these requirements just in case they have an audit, and because they have to keep records for 5 years. But ultimately, it will be on the European company to ensure that its records are kept for 5 years rather than the records of the suppliers.
Thanks, Nikolay. What about recycled products? If an exporter can show that its products are recycled, does that take them out of the regulation, or are they still subject to the regulation?
So if the relevant product, is entirely recycled, and unfortunately it's almost impossible to satisfy, but if it's entirely recycled, then it's outside of the scope of regulation. If, however, like with recycled paper, there's only like 1% of non-recycled paper in a lot. Like every client we have the same issue, that what they call recycled, because of tolerances, it has 1 or 2% of non-recycled paper, and it immediately takes us back within the scope of the deforestation regulation. So if you're 100% recycled, then yes, there is no concern on the deforestation side of the deforestation regulation with those products. But reality is more complicated, unfortunately.
Okay. Question about satellite images and geolocation. You've mentioned the need for geolocation and satellite images a number of times. The question is are the satellite images specifically mentioned in the European regulation, or that's your conclusion as to how compliance should be met?
It's our conclusion as to how the compliance should be met because of the unprecedented high legal threshold set by the regulation. Because you need to generate due diligence statement, if you think about it, there should be no risk of deforestation, to cut long story short. So you need to have positive evidence that the product is deforestation free. And that evidence in turn, so not only your assessment has to eliminate any risk, you need to back it up as a European operator. So you, a European operator, you need to have evidence in Europe that is conclusive and verifiable. So the regulator comes and checks in real time, what do you have? What do you have to show me that the product is coming from the land plot which was not deforested? That means that you need to have something more than the certification from the supplier, because certification from the supplier is not adequately conclusive or verifiable. I, as regulator, I cannot check the certification from the supplier that the product is deforestation free, right? I mean, I can travel there possibly, but it's not, for us, it's not adequately conclusive and verifiable within the meaning of regulation. So because of the size of the penalties and because of the threshold Europe sets, our recommendation to be on a safe side right now is to try to ensure that you implement within your SAP essentially a module which in real times allows you to and it's gonna be difficult in the beginning, but which allows you to check for each geolocation whether it's what is the risk of deforestation or forest degradation for it. And at the end of the day, each supplier will have only that many land plots, and as soon as you deal with certain supplier for a number of them, you would qualify pretty much all of them, and then the need to constantly go to the satellite imagery database will reduce. In the beginning, the workload will be relatively heavy, but again, from the legal requirement side, we think that it's better to err on the side of caution, just because the language in the regulation is extraordinarily strict and burdensome, and we haven't seen this kind of requirements in other European compliance instruments. If there are other ideas, of course, we are happy to consider and discuss with the Commission as part of setting up the due diligence system. Having said that, from what we hear from the Commission, what they are doing with the regulators, they are setting up access to all the regulators to the databases with the satellite images. So what will happen in real life? They're going to take due diligence statements, they're going to take your geolocation data, and they're going to run it through their own Starling or whatever database ultimately, which will win the procurement contract. And they're going to say, look, I have here red parts of the plot, or entire plot is red. So what do you have to show me in terms of conclusive and verifiable information? And the only way at this stage to defend yourself would be to say, look, hypothetically, I'm signed up to another service provider. Here there are images. They may have high resolution. I check with a third party, who is the image basically service provider, and they tell me there is a deforestation free. On that basis, I think legally we'll be able to get away. But the way the regulators are implementing it, it points to the requirement to have satellite images within Europe, in fact, to be compliant to the extent the regulation requires.
Thanks, Nikolay. I think we'll leave it there in terms of questions. There are a set of additional questions, but we could go on for much of the morning or Nikolay's evening. If you have additional questions, please send them in by email to Nikolay or to Christian or myself or Bill Bunker. I want to thank all of you for participating. Special thanks to Nikolay. Thank you, Christian. Christian, any last words on your side? You're living this reality in Brazil every day.
Absolutely. I found the questions very, very interesting, to be honest. There was a particular one in relation to timber, which we will not be able to answer, but I will ask Nikolay about it after the call, because it's quite interesting. Because if you harvest timber, by definition, it's forest. What do you do then? What do you need to provide to import or to export timber into the European community? So, well, it will be very cumbersome, will be very costly, and ultimately the consumers will have to bear that cost, I suppose.
Yeah. One last housekeeping point. We have a recording of this. We also have the slides. If any of you would like the recording or the slides, please be in contact with us and we'll provide them to you. Again, thanks for participating and good luck on your geolocation. Thanks again, Nikolay.
Thank you, everyone.
Thank you. Bye.